Starting.
Yes, Jimmy's done. I'll start. Hello, welcome, and thank you for joining the webinar on how to get involved in the State Department's work in private international law. My name is Professor Stacy Strong. I'm one of the co-chairs. My other co-chair, Cristian Jimenez-Corte, is on with us, although he very kindly is going to let me be speaking. I'm basically going to introduce our speakers, who are fantastic, and then they will take it over from there. If you have any questions during the session, please send them to Julia Knox at ASIL. She will then send them along to me, and we'll make sure that our speakers have a chance to answer them. So first, we have our main speaker is going to be Mr. John Kim. He is the Assistant Legal Advisor for Private International Law at the Department of State. It is fantastic to have him with us today, since I know some of his colleagues are down in Vienna at the Working Group 2 meeting for UNCITRAL, busy working on a proposed treaty. Mr. Kim has served in the Office of the Legal Advisor for over 20 years and has worked in a number of different capacities, including as the Assistant Legal Advisor for Treaty Affairs, the Assistant Legal Advisor for Oceans, Environment, and Science, and as a Legal Advisor to the U.S. Embassy in The Hague, where he reported and advised on various developments with the international courts that are resident there and various organizations at The Hague. He is going to be discussing various issues with Professor David Stewart, who is at Georgetown University Law Center. Prior to joining Georgetown, David was at the U.S. Department of State, where he was the Assistant Legal Advisor for Private International Law. So we have the two top people in the field here with us today. He had previously worked as the Assistant Legal Advisor for Diplomatic Law and Litigation, African Affairs, Human Rights and Refugees, Law Enforcement and Intelligence, International Claims and Investment Disputes, as well as a Special Assistant to the Legal Advisor. He was also in private practice for a number of years before joining the Department of State, and currently, as I said, is at Georgetown. He serves in a variety of capacity with a number of organizations that you are probably members of or have heard of. He is president of the American branch of the International Law Association, a member of the board of editors of the American Journal of International Law. He's on the executive council of the American Society of International Law, and is one of the reporters working on the restatement fourth of the Foreign Relations Law of the United States. So with that, I will give it to David and John to take it away. Again, I encourage you to send your questions. No question is too simple or too complex for these gentlemen. Also, we are very good about not saying who the question comes from, so don't be afraid that your question is going to be named to you, and then you're going to feel silly about it. So go ahead and send those in. I give it over to David and John.
Thanks very much, Professor Strong. It's a delight to be on this session. Thank you for arranging it, and I'm particularly honored to be able to participate with my friend and former colleague John Kim, who really is a true expert. And this offers an opportunity for all of you on the webinar who are interested in the growing field of private international law, one of increasing importance, to ask someone who's directly involved whatever questions you may have, and more importantly to find about what's currently going on. So John, if you would start us off by perhaps introducing yourself in a little more detail and explaining what the Office of Private International Law in the State Department actually does.
Sure. Thank you, David, for moderating this discussion, and I wanted to thank Professor Strong as well as the American Society of International Law for hosting and organizing this webinar. I've never done a webinar before, but I'm very honored to begin with this one. And you know, it is an exciting time for private international law. There's a number of proposals and ideas out there, and we welcome the involvement of others. In fact, we need and depend upon the involvement of students, practitioners, professors, and others in the field. I'm not going to say too much more about myself. I've been a career lawyer in L for a long time, working in many different offices. I also, like David, was in private practice for a while, and but for about the last 2 years, I've been in the Office of Private International Law, which is a somewhat different kind of office within the Office of Legal Advisor at the State Department. So I want to explain that a little bit. For those of you who may not be familiar with private international law, let me offer a brief working explanation. Private international law focuses on the negotiation of treaties, model laws, instruments that regulate private transactions that take place across international borders. As this audience can well appreciate, increasingly business relationships, online transactions, property interests, even families or children are crossing national borders. And we need to know which law is applicable to those transnational situations, and we need to make sure that whatever law does apply, hopefully is favorable to or consistent with U.S. interests. So as a result, private international law covers matters such as jurisdiction, choice of law or conflicts of law, and the recognition and enforcement of judgments.
John, the things you've just described often don't strike people as standard fare for the Department of State. And one question that's often raised is, why is the private international law function of the United States rooted in the Department of State, and in particular in the legal advisor's office?
Well, as I indicated, our office is somewhat different than other offices in L. Most offices in L, or almost all of them, are essentially responsive to the needs or questions of a client bureau, we call it, such as the Middle East Bureau or the Arms Control Bureau. And they largely address matters of public international law and sometimes domestic law. Private international law is somewhat different in that we're kind of almost a policy and a legal office. We have to identify the policy objectives in our area and then seek to implement those objectives. Now, there's many different countries handle this function in different ways, but the reason the Office of Legal Advisor is involved is that, A, most of the international discussions of these topics are fairly legal and very technical usually, and so it requires some specialized expertise. And second, many of these negotiations of these instruments, treaties, model laws, etc., take place in multilateral fora. These three international entities or organizations. And therefore, once again, this is an area that requires some specialized knowledge and obviously some experience negotiating with other governments. So this function has, I think, correctly been lodged in the Department of State, although we don't actually deal with too many client bureaus, sometimes with the Economic Bureau or the Consular Affairs Bureau. But we, in fact, interact very closely with the members of the public, of the private bar or the academicians. I also just wanted to mention, it's interesting, different countries handle these types of functions in many ways, different ways. Some countries lodge these types of responsibilities in their ministries of justice, so in their justice departments, such as Canada and Australia. Other countries, the work is just spread out among different countries, different departments, or agencies. For example, Japan, I notice, has some functions housed in the Ministry of Justice or the Ministry of Foreign Affairs, but also some are essentially contracted out to private experts or consultants. So there are different ways that that this work is parceled out, but I think we're very lucky and unique in that it's all kind of centralized at the Department of State, so we can kind of see the big picture, if you will. It also makes it harder too, because we obviously are not the experts. I personally am not on all these specialized areas of law, whether it be judgments or letters of credit. And so we very much rely on the input and expertise of practitioners and academicians who specialize in these certain areas of law, and we bring them in and we draw upon them in our work.
Can you say a few words more about the way in which you draw them in? How do you consult? There are a lot of different practitioners, as you say, experts, people who specialize in these very technical areas.
Right. Well, this is one of the reasons I'm very excited to be at this webinar today. We wanted to educate you a little bit about what we do, but hopefully we also want to invite all of you to learn and participate in the activities of the Secretary of State's Advisory Committee on Private International Law. This advisory committee is really one of the primary ways that we do learn from and draw upon the expertise of experts and academicians, etc. The Advisory Committee on Private International Law, or ACPIL, as we like to call it, was established in 1972 under the authority of the Secretary of State. The committee is usually chaired by the legal advisor of the State Department. And the purpose of ACPIL is to advise the State Department with respect to significant issues of private international law that arise, as I can mention, in the work of certain international organizations. So, as I suggested, the Advisory Committee consists of all kinds of people, members of private sector organizations, bar associations, law schools, national legal organizations, and other federal and state governmental entities or governments even. So, and they help us with areas such as family law, which is another big area of private international law that I should mention. We are not experts in that, but we have a group of family law experts who advise us. Judgments and arbitration, judicial cooperation, things like that. So in short, the committee is a really valuable and important resource. It's a great way for us to reach out to the public and get their ideas and views, as well as to the experts. We let them know what's going on and get their views as to existing projects. So it's a very useful resource. And I just should quickly mention that the next meeting, we'll hold an annual meeting of the Advisory Committee, and it's going to be held on September 25th at Georgetown University Law Center. Thanks in large part to David Stewart. And so I hope all of you take a look and consider coming out. It's open to the public.
We just had a question on that very point. Do you have to be a member of any particular organization to attend ACPIL? Or it's open to the public?
It's open to the public. You do not have to be a member of any particular organization, and we'd welcome your attendance.
Do you have to register in advance?
Yes, we normally do ask people to call in to our office and just register or let us know that you're coming, so we'll have a nameplate and we'll know that you're there. So yes, that would be helpful.
Okay. We had two more questions while you were talking, John. I can answer both. Do you need to be senior in order to come? And the answer is no.
No.
And do you have to have any particular expertise? And the answer is no. Because, and I know this because I've encouraged my students to attend. It's a great opportunity to learn about this area, even if you know nothing about it.
That's right.
Can we go back just a bit? You mentioned earlier, John, that at the international level, much of the activity in the world of private international law takes place in a multilateral fora. Can you say just a few words about what those organizations, those fora, how do they operate, where are they, what are their agendas?
Sure, absolutely. Private international law activities primarily take place in one of three institutions. The first is the UN Commission on International Trade Law, or UNCITRAL, as we call it. It is headquartered in Vienna, and it meets usually about 2 to 3 times a year in Vienna and then in New York City at the UN headquarters. So that's the first one, and the biggest one, perhaps. The second is the Hague Conference on Private International Law, often just called the Hague Conference. This is, not surprisingly, based in The Hague, the Netherlands, and they hold periodic meetings. They're not as they don't meet as regularly as UNCITRAL, but they do have working group meetings, expert group meetings, usually in The Hague, although it can change, and they have some annual policy meetings in The Hague as well. And the third organization is one that I did not really know much about until I started this job, which is the International Institute for the Unification of Private International Law. It's a mouthful. It is called UNIDROIT, U-N-I-D-R-O-I-T. I think that's the acronym for the French. And that is based in Rome, Italy, So that probably wins the cake for best location or most attractive location for some. And it's a fairly small organization, and then it has a governing board which consists of various members, including for us, for the United States, we're on the governing board, and we have a professor who sits on that. Now, so these are the three big multilateral fora, but I would be remiss not to mention a number of regional or other multilateral type organizations which perform work on private international law matters. Perhaps one of the most noteworthy is the European Union, which is in Brussels. It has adopted a number of regulations touching on private international law matters, such as recognition and enforcement of judgments, for example. There also is the Organization for American States, which David knows a lot about, and that's obviously the Latin American countries, and they've done some work in the area. And then the third, and I think one of the more exciting regions right now, is the Asia-Pacific Economic Cooperation Forum, or APEC. We have been doing some outreach to that group and working with them, and they are very interested in looking at model instruments as well as private international law conventions as a way to enhance the ease of doing business in the Asia-Pacific region and to reform their laws to make it easier for businesses to operate. So that's kind of a breakdown. So there's three big multilateral ones, or three multilateral, and then some regional organizations.
Each of these organizations works a little differently and has a slightly different focus. One function of your office then is to watch all of them and to try to some extent promote U.S. interests in a coordinated fashion, at the same time looking domestically, seeing what our domestic priorities and needs may be. So in a sense, you're in a way like a traffic cop, but it leads to the question, how do these various organizations decide what topics to pursue? They all can't be pursuing the same thing, and how does your office decide, well, this is something we'd like to follow, and let's do this in the Hague Conference, or this in UNIDROIT, or make choices, because you're kind of in the middle here.
Right. No, it's very true, and it's not always so easy. We have been undertaking some steps, though, to try to coordinate or have better coordination among the three private international multilateral organizations, at least. And frankly, they don't want to be stepping on each other's toes either. They want to be they don't want to be duplicating necessarily the work that others are doing. But there are necessarily some areas of overlap, for example, in recognition and enforcement of certain types of judgments. Some types of commercial law, there's going to be some overlap. So there certainly is a potential for that. But the short answer to your question, David, is that the organization's agendas are determined by the member states themselves. So now, suggestions for these projects can come from states, secretariats themselves, or from non-governmental organizations. And essentially there's a vote, or essentially people discuss it and they arrive at a consensus on what types of projects they think are worth pursuing. And I think one of the steps that people will take in the course of that is figuring out what other organizations have done or are thinking about doing in the area as well. One thing we have found is that as organizations develop expertise and experience with particular areas, they tend to develop they tend to keep projects in these areas, and they kind of develop new ideas or new projects. So, for example, UNCITRAL has 6 working groups, and they've been working, for example, in the area of arbitration in Working Group 2, which is currently meeting in Vienna. And they've been doing so for many, many years, and they've been working on various projects. For example, they developed the UNCITRAL rules on arbitration. They most recently worked on the UN Transparency Convention, which I can talk about. And now they're beginning discussions of on a possible instrument, possibly a convention, on the enforcement of conciliated settlement agreements. So UNCITRAL, for example, has established working groups that seem to work for a while. Like they have one on insolvency, they have one on secured transactions, etc. Electronic commerce is another area where they have it. The Hague Conference, for example, tends to focus on family law. They're the only organization I know that does family law, and so they have generally there's always something in the mix or something being considered in the family law area. But they've done some good treaties in that in the family law section. And then the Hague Conference also has been kind of focused on the Judgments Project, on recognition and enforcement of judgments. And so that's an area where they tend to focus. So it is a little bit playing traffic cop, but there's also established patterns among some of the organizations on the type of work they're doing. But in terms of how we proceed and how quickly do we proceed, what are the domestic needs in private international law? Frankly, we may develop some thoughts or ideas in that area, but we truly depend on the input of experts, practitioners, and academics to develop ideas for projects in new or different areas of law for these organizations to tackle. And so that's one of the reasons we hold the annual ACPIL meeting, which is on September 25th. And that is also why we also hold study group meetings, or I forget what, we hold public meetings on various projects periodically to try to get the input of the public and learn from that.
If I were a young professional or even an older professional and I had a suggestion or a particular interest in one of these projects, an idea for you, is the only way I can communicate that by going to the ACPIL, or is there a way that, do you solicit recommendations? I know that on some of these negotiations, you have private sector experts on the negotiations, but Stacy reminds me also, or someone did, that ACIL itself has consultative status with the UN and therefore can attend, sends people to attend UNCITRAL. But speaking from the point of view of a domestic lawyer as an idea, saying, here's something I think the government ought to consider, how do they communicate that to you?
Great question, and glad you raised it, because essentially there are numerous ways you can make contact with us or my office. You can contact me or any one of the lawyers or staff in our Office of Private International Law at the State Department, by email, by phone. We have a website, which is on the State Department legal website, legal advisor's website. We also hold these periodic meetings that I mentioned on specific subjects like electronic commerce or family law. And then we have the annual meeting, which is just a good opportunity for all people to get together. But the door is always open, and there's many different ways you can contact us by email or by phone. And then, as you mentioned, we also often have experts or practitioners joining us on the delegations when we go to working groups or negotiations on specific treaties or model instruments. So there's many ways for a young or senior professional to get involved.
Or even people in the middle.
Yeah.
Yeah. Would you, if we can turn to the substantive issues for a minute and talk, or for several minutes, and talk in a little bit more detail about things that are currently on the priority agenda for the United States. So you've got some areas in which you're particularly focused. Can you describe the most important or the most interesting?
Sure. I'm happy to. As I kind of got to learn the work of the office, I set certain priorities for the office. The first being, I noticed we negotiated a number of treaties, but they had not progressed very far in terms of transmittal to the Senate or ratification. And obviously, it's important for us to show that we can, try to become parties to some of these instruments that we negotiate. So one priority has been the domestic implementation of existing PIL treaties, and there's many of them. And so one of the things we've done is during the last year and a half, we've prepared treaty transmittal packages on 3 separate conventions: the UN Convention on Independent Guarantees and Standby Letters of Credit, the UN Convention on Electronic Commerce, and the UN Convention on the Assignment of Receivables in International Trade. These are UNCITRAL commercial law treaties that are generally well accepted. We also have made a lot of progress on the Hague Child Support Convention, which was had already received Senate advice and consent, and then we got federal legislation, and now the last component is that we need some all the states to pass some uniform state law, and that's been progressing very well. So we're trying to make, and then the latest is, last thing I should mention is that we had one treaty that was already submitted to the Senate by President Obama. It's the Hague Convention on Securities. It essentially is a choice of law convention for securities that cross international boundaries, which almost all of them do. And we briefed the Senate, and the Senate has recently informed us that their plan is to hold a hearing on this treaty this fall. So that's clearly one area of focus and priority for the department, for me at least. The second is that I think that private international law used to be kind of the province of the WEOG, as I like to, it's kind of the Western and other European and other groups. It used to be Europeans and the Americans and the Canadians, etc. And I think increasingly private international law needs to move and reach out to other regions of the world, whether it be Africa, Latin America, and Asia. And I think one of the initiatives we've taken is to push in all these regions, but certainly the Asia-Pacific region. As we mentioned, we've been, one of the lawyers in my office has been going out there and attending meetings, and they've just established a legal subcommittee within their economic committee. And so they're looking at these various private international law instruments as a means to enhance trade and investment. And so I think one of the other priorities has been to try to reach out to other regions and to promote instruments in the other regions. And then the third priority I'll mention is that there are obviously certain, I think, projects that are of interest. I mean, we're interested in all these areas, and I'll talk a little bit in further detail maybe later, but I'll just mention two substantive priority type projects that we're working on. One is a project on a convention on the recognition and enforcement of foreign judgments. This is happening in the Hague Conference on Private International Law. There is a draft of a possible convention in this area, which would be, I think, a really game-changing convention if it was actually to happen. Especially because many, the American courts are among the most receptive to recognizing and enforcing foreign judgment. But we have American litigants have more difficulty getting their judgments recognized and enforced in other countries. So that's one substantive priority. The other priority, and this is one that's been there for a while, I imagine, and that's in the area of dispute resolution. Also, and it's in UNCITRAL and Working Group 2. We just finished negotiating a convention on transparency and investor-state arbitration. As some may know, this has been a very interesting and somewhat political area where folks are interested in having greater transparency in investor-state arbitrations, because these arbitrations often raise issues that are of a political or governmental nature that people are interested in and want to hear about. And then secondly, also in the UNCITRAL Working Group 2 on dispute resolution, we are currently discussing a possible convention on the enforcement of settlement agreements. The idea behind that is to kind of give a boost, like the New York Convention did to arbitration awards, give a boost to the to conciliated settlement agreements and make their enforcement around the globe easier. And if that's the case, then it may be more likely that litigant or disputants will take their claim and adjudicate them through a conciliated settlement. So those are some of the substantive areas. So we obviously have some areas that we'd like to kind of focus on substantively, but those are kind of three priorities for the government.
Terrific. That's very helpful, and your comments have already generated a number of questions. Let me see if we can, if I can put three on the table for you to respond to. In each of these areas, clearly conflicts of laws, choice of laws, a central concern in almost every area, conflicts between different legal systems or from the point of view of the private practitioner. One of our participants asked, is there a relationship between the things that you negotiate, the positions you take, instruments you develop at the international level, and conflicts of laws in a domestic context? It's a very thoughtful question, but maybe we can generalize it a little bit and say, how important is conflicts of laws, choice of law issues, that package of issues in the context of private international law? And then let me add, John, if I can impose a second question, how important are regional organizations in the larger scheme? You've mentioned in particular the three large multilaterals, but one of our participants asks, well, okay, but how important, what's the particular added value of the regional organizations? So one on choice of law, one on regional organizations.
Well, those are good, very good questions. They're large questions, so I'll try to be as responsive and helpful as I can. And the two questions are linked, of course, because in fact, different regions of the world or countries in the world have different views on how which law does pertain to a particular transaction that crosses national boundaries. So the short answer is conflicts of law is very important, and choice of law is very important. I can just make mention of the Hague Securities Convention, which is something I'm more familiar with, and it is a convention focused on the choice of law, and it establishes a choice of law it's essentially the place as agreed between the parties. But that was not the choice of law, for example, in certain other countries in Europe, for example, that had the place of the account, or the securities. So those issues come up constantly in our work, and there's often very difficult negotiations and discussions on how to harmonize or construct a suitable choice of law that countries will accept. It's often quite difficult. Another example is, and this also ties into the regional organizations, for example, another negotiation is on the recognition and enforcement of foreign judgments. Well, many countries have different rules on how they recognize and enforce foreign judgments. It's quite remarkable. The Hague Conference has actually produced a paper on all the different ways that that different countries recognize and enforce foreign judgments. Some countries would recognize judgments if they are based on a jurisdictional ground that we recognize and that was also recognized in the foreign court. Other countries don't necessarily do it that way. They only recognize and enforce foreign judgments if they meet certain specified criteria. And they would not even recognize something that was done on the basis of jurisdiction that their domestic courts would recognize. There's kind of a gap between the direct and indirect bases of jurisdiction. So this issue is fundamental and paramount. We struggle with it throughout private international law agreements. And in the context of judgments, for example, you have the European Union that has already passed the Brussels I regulation as recast on the recognition and enforcement of foreign judgments, and so they've already covered some of this ground. And so you have to contend with kind of their internal regulations and how they view jurisdiction and the recognition and enforcement of judgments. And then you have to, and then Canada, for example, has a different model and different rules. And then we have a set of jurisdictional rules that are quite different, and that in our case are based on the constitutional provisions of due process. So in negotiating this type of instrument, you have to kind of take into account the different rules within each country and the conflicts that invariably are there between different countries or regions. I hope that's helpful.
I hope so, and we'll hear from our participants. We do encourage more questions because that's the point of the webinar. Let me ask you another question with regard to treaty implementation. You gave a very helpful description of the various packages of treaties you're submitting or have submitted to the Senate. And always it's trying to get treaties through the approval process, advice and consent in the Senate is difficult. But one of the things I think the United States faces that many other countries do not are issues of federalism in the context of private international law, because many of the issues that you've described, for example, in the world of commercial law or in the world of family law, are largely, not exclusively, but largely not federal law in the United States. And of course, the result of a treaty is that the substance of that treaty becomes federal law under the Supremacy Clause. So can you say a few words about this rather tricky but certainly very complicated aspect of private international law and how that complicates things for you?
Yes, as you well know, David, this is perhaps one of the most complicated areas of our work, which is, it's one thing to go out there, and it's difficult enough to negotiate a treaty with our international partners, because as you know, we just discussed, there's different rules for different types of in different areas, such as recognition and enforcement of foreign judgments, or the choice of law that should take place, for example, for a securities transaction. But even when we get home, it gets perhaps even more difficult, and that's because, as you noted, many of the areas in which these treaties regulate are within the United States traditionally the province of state law, or at least have been largely regulated or by state law. And it is very tricky and difficult because it obviously raises issues of federalism and the proper balance of state and federal law, federal-state relations. And this is a serious issue, and frankly has given rise to pause and some difficulties sometimes in the domestic implementation of our treaties. So, for example, there is something called the Choice of Court Agreement, negotiated at the Hague Conference. It essentially recognizes and enforces agreements between parties, commercial parties, on the choice of court or the forum. Now, this is perfectly consistent with U.S. law. We support it in principle. There's no disagreement. I mean, within, on the substance of the principle, and there's a lot of support for it internationally. But one of the difficulties this treaty poses, and this is present in other treaties as well, is that how do you implement it? Do you implement this through a federal statute on the recognition and enforcement of choice of court agreements? Do you enforce it through uniform state law? Because this is recognition and enforcement of judgments has traditionally been the province of the states. Or do you do it through some combination of a federal law and state law? Something that's often referred to as cooperative federalism, which is where, because it's a treaty and we need to implement it and meet our obligations, there needs to be a federal law or backdrop. But then that federal law or backdrop is it doesn't apply if a state passes a certain conforming state legislation. And so this is something actually we're going through right now with the Hague Child Support Convention, where we have a federal legislative backdrop, and then that will apply, but because family law is obviously an area generally regulated by the states, we have created a mechanism whereby states can enact and are encouraged to enact uniform state law that implements the provisions of the convention. So, in short, this is a very large area of analysis and sometimes difficulty for our office, precisely because many of the issues regulated by these conventions and instruments reside in the area of state law within the United States. Now, it's not true for all treaties. For example, the UN Convention on Transparency and Investor-State Arbitration does not raise state-federal issues, thankfully, and so it doesn't always come up, but it often does. And then one thing I should add is that I've been mentioning these uniform state laws, and I think one of the prominent people or organizations with which our office engages is an organization called the Uniform Law Commissioners, which is a group of commissioners from all 50 states, and they meet periodically and one of the things they enact are uniform state laws to try to create kind of harmonized state law across the country. This organization, the ULC, is responsible most prominently for something like the Uniform Commercial Code. And so they are one of the organizations we tend to work with fairly often, for example, on family law conventions, or we've been talking to them about the judgments conventions, because as I indicated, so many of our conventions implicate areas of state law regulation.
Let me pursue that, particularly because, John, you, in a former iteration, you were in fact the assistant legal advisor for treaty affairs. So let me follow up this discussion with one question. Is there any particular reason why we can't just federalize things by saying, well, it's a treaty, it's been addressed at the international level, so that's that. Too bad. Our founding fathers had an idea at the outset. They never really contemplated things called private international law treaties, but that's the Constitution, and we need to have uniform, stable law that allows us to participate in the international community. Seems to be pretty straightforward as a constitutional matter.
You're trying to get me into trouble, David.
Yes. Just asking for our views.
Well, I wish it were quite so straightforward. But obviously, there is a constitutional basis for the federal government negotiating and entering into or concluding treaties. And obviously there are provisions of the Constitution like the Commerce Clause, et cetera, that would provide a basis for federal action, for example. But I guess my short answer to your question is, that may be nice in theory, or it may agree with some people's theories, but it doesn't work in practice. Because as a political matter, our experience is that the Senate is very interested and aware of the state-federal issues, and has expressed concern at times that the balance of state and federal law be appropriate. And that we can't just go ahead and federalize, all areas. For example, areas like family law. It may be that we need to recognize and enforce child support agreements, and we could pass presumably a federal law to that effect. But this is an area that's so closely associated with the states and state law that, as a practical matter, we need to find some way to try to work cooperatively with the states and reach an agreement that can achieve political consensus or agreement.
And that leads to the next question, which is the use of instruments other than treaties, conventions, binding legal instruments, in order to advance the objectives of private international law. Pretty much everything you talked about earlier, by definition, were treaty projects. But in the world of private international law, do you see a lot of other instruments which are not legally binding? Some people use the term soft law. I'm not a fan of that term, but things that would be normative to some degree and useful, maybe capable of adoption by private parties, and yet not legally compulsory.
Oh, absolutely, and I'm very glad you raised that question, because I actually think that the trend in the future is going to be toward these non-treaty or soft law instruments, or non-binding instruments, I'd like to call them, non-legally binding instruments, certainly in the private international law field, but perhaps more generally in foreign affairs. I think, I don't think I'm surprising anyone to say that treaties, multilateral treaties in particular, are difficult to negotiate and they're difficult to bring home and ratify, and that's been the experience of any private international law treaties. They don't often get as much as widespread ratification as you might hope, aside from a few exceptions. So yes, I think we're going to see much more of what has been done in private international law throughout its history, which is that there's going to be the development of model laws, model instruments, technical documents or model rules that will, I think, that could be very successful and provide a model for many countries. So, you know, we recently did an exercise where we listed all the private international model laws or rules or statutes that people have developed over the years, and many of them have been extremely successful. They've been the basis for legislation, domestic legislation in many countries. For example, the model rules on electronic commerce, model rules on insolvency. I understand both those have been very successful in encouraging other countries to adopt legislation. And I think, so those are actually quite useful and can help in the harmonization of concepts and rules across the globe.
Okay. Your comments have generated a few other good questions. Let me give them to you there are three of them I want to raise. The first, going back to your discussion of regional institutions, is a very pointed one. Private international law in Europe, I think the questioner has in mind through the European Union, is having a massive resurgence. To what extent does the State Department look to the EU for ideas and input and inspiration in the area of private international law, or to what extent does state attempt to harmonize the U.S. approach? I'm not quite sure what the second part of that means. I suspect it means harmonize it with the EU's approach. So what can you make some comments about, because we know that the EU functions very differently than any other institutions. So have some comments on that?
Oh yes, I certainly have thoughts on that issue because it's come up in two projects that I've been involved in. One is the Judgments Project, where the other major player on the negotiation of a judgments treaty is the European Union, basically. They're a big economy, they have many member states, and they're very interested in a judgments convention. And so I've been spending a lot of time better understanding their Brussels I regulation, as well as conferring with them in bilateral consultations to try to learn from each other and try to see if there are areas where we might have some overlap and some basis for compromise. And so that's very much a factor, and they're a very large and significant player in private international law, because as you noted, they are getting involved in many areas of private international law. You know, one of the difficulties, of course, is that we each have our own different systems. You know, the European Union and the European countries, as well as many other countries, have more of a civil law or civil code system, which is, you know, everything is written down in significant detail, and there are very specific types of rules that govern transactions. For example, in the area of judgments. That's not true for us so much. Obviously, the area of jurisdiction and judgments is judge-made law for the most part. So, they're very much a factor that we have to consider, and it does affect our negotiating strategy, and it affects what we can hope to achieve as well. And that's actually also one of the reasons why we're looking at other fora like APEC or the OAS as possible fora that may be more favorable to U.S. interests. The other area where I think it's been difficult is in the area of online dispute resolution in the UNCITRAL, where, you know, we essentially ended up with a technical document which has some model provisions on online dispute resolution and kind of, you know, who is a neutral, what the process should be, etc. But we couldn't achieve more than that in terms of model rules, in large part because there was a big dispute between mostly the European Union and some other countries, and the U.S. and some of its other countries, regarding the use of pre-dispute binding arbitration. The United States permits and has a system that is comfortable with pre-dispute binding arbitration, even for consumers. But the European Union does not feel comfortable with having pre-dispute binding arbitration agreements for consumers. They don't consider it sufficiently protective of consumer interests. So that's an area where we had a big conflict and difficulty with the EU in one of these multilateral fora. And so it's these differences in approach and differences in regulation really do make a difference, and we have to try to accommodate that. And it's also, I think, one of the reasons why it may be harder to get treaties or conventions negotiated, and that perhaps model rules or model instruments could be, I think, the trend in the future.
That's interesting. Okay, we're getting some really great questions. Here's another one. I'll call this one the professor's delight. What exactly is private international law? Or more particularly, what's the difference between public and private international law? The questioner may not know that in this particular field, some people insist upon calling it international private law as opposed to private international law. This is an interesting debate, but John, do you have an easy answer to the how do we define this? What's the limits of the field?
Well, I can tell you how I view it, which is I think we call it private international law, which I agree is a bit misleading and confusing because it is international, but it focuses on transactions among private actors, that is, U.S. consumers, citizens, U.S. businesses, and when they go cross-border, when there's a cross-border situation, or when they have a business deal or a trust that crosses the border, and so it's international and it's negotiated among governments. So it's international law and it's done at multilateral fora, but it's essentially regulating the conduct, or hopefully assisting the conduct of private actors, whereas public international law, which is the law that you and I probably have spent most of our time doing, involves the actors of governments, essentially, of treaties or model law or whatever that regulate the behavior and the obligations of countries and our governments. That's how I view it. I hope that's helpful. David, you're the professor. Maybe you have a better thought on that. But.
Well, I agree entirely with what you've said. The point that I sometimes make is that it's private international private law. The difference is, of course, that it's states getting together, primarily in these international fora, and agreeing on the rules that they're going to apply to the private transactions when they cross borders. So it is a form of international law, but it affects private relations, and it's done for the purpose not simply of unification or harmonization for the sake of unification or harmonization, but for the sake of efficiency and clarity, and in the case of commercial relations, risk reduction, or in the case of family relations, sorting out problems effectively and efficiently in light of what folks think are the important policy interests. So all the states have public institutions designed to resolve disputes, to clarify things, to promote commerce. The real object of this all, though, is to promote the interests of private individuals, private entities, economic growth, development, rule of law, all of those things. So to some extent that exists in public international law too, although I might say that that's also about conflict avoidance at the international level, which is not the subject of private international law. I don't know if that adds anything to it. One of our listeners, our participants, has asked whether how did one gets involved in the Uniform Law Commission. Unless you have a better recommendation, I would say you got to go and ask the Uniform Law Commissioner. That, as you pointed out, the commissioners represent states, and they're appointed by the states or by the governors or nominated, elected by the legislature, different ways in which you become a member of it. They do have various ways in which you become involved, but that's not your purview.
No, I can tell you that they have a very good website, which you can go to. You just put it in the internet and Uniform Law Commission, and I'm sure they'll give you all the requisite information. But they're based in Chicago, and yes, as David indicated, I think there are different states have different ways that these commissioners are elected or nominated.
Can you say a few more words, perhaps, about international family law, which, in my experience, is certainly for general practitioners and for law students, relatively unfamiliar territory. There are, to my knowledge, still relatively few classes around in the various law schools on international family law. But from what you've said, it's a big part of your office's focus.
Yes, I mean, obviously the work ebbs and flows in terms of family law, but most of it is done at the Hague Conference on Private International Law, and there is much work happening both domestically and internationally. I have to confess, I don't know that much about family law myself, although I've been learning a few things. I mentioned on the domestic front, we're hopefully in the final stages of domestically implementing the Hague Child Support Convention and get that into force in the United States. And in that connection, we're waiting for a few more states to enact a uniform state law before we'll recommend to the President that he ratify the instrument, ratify the treaty. On the international front, there is a lot of exploratory work taking place at the Hague Conference. And it's very interesting. For example, there's been an experts group that's been convened to explore the feasibility of advancing work relating to private international law issues regarding the status of children, including those issues arising from surrogacy arrangements. And I have to confess, this is an area I don't know that much about yet, but I gather surrogacy arrangements are increasing. Across the world, in certain countries, there are more of them, and there are often questions that arise as to the citizenship of the child, the rights of the parents, etc. So that's an area that's undergoing some exploration at the Hague Conference. There's also some exploratory work that the Permanent Bureau of the Hague Conference, which is the Secretariat, they're doing some work on the recognition and enforcement of foreign civil protection orders. So that's another one in the recognition and enforcement area. And then finally, an experts group will be meeting to consider the role that existing family law conventions play in cross-border recognition and enforcement of voluntary family law arrangements or agreements. And so there's a lot of work essentially happening in terms of how do we protect, the rights of children in particular, but also of parents when spouses cross borders, children cross borders, and this is kind of a very kind of a critical area of private international law. It's very interesting.
And very important.
Yeah.
John, we're almost out of time. Before I turn it over to Stacy for whatever she would like to do by way of closing, let me ask whether you have any final exhortation to people who say, this sounds like a really interesting field, I'd like to get involved.
Sure. Well, I think it is an interesting area of law and practice, and I really encourage anyone who's been listening or who might be might see the transcript to think about getting involved in private international law. Please come out to the annual meetings of the Advisory Committee on Private International Law. They're usually all day, but you don't have to stay all day, and you can learn something and kind of get a sense of what we do. And I think it's it's a great way also for private practitioners or law students or professors, or corporate lawyers, to get to make a difference, and to do so in areas that they already have an area of expertise in, and to and perhaps even and have some fun. You know, you're joining us on delegations or advising us on negotiations. I think this is really one of the neat parts about this work, is that we work with real lawyers. It's not just the government lawyers or government agents. It's really so we're really trying to, we want to work with you, the practitioner, the people in the field, to try to make things work better, whether it's in the area of family law or commercial law, etc. So hope for your interest and support.
Terrific, John. I'll just add to that, government lawyers are real lawyers too. Professor Strong.
Wonderful. Thank you, David, and thank you, John. I will reiterate to all of those who are still on the line that ACTPIL is a very welcoming place. The lawyers at State are fantastic at listening to new ideas and really encouraging new voices in the discussion. I think John will agree with me, because I heard it from him first, that he is very much looking for new players in this particular area of law. He really wants people to come out, give their stakeholder opinion. So please feel free on September 25th at Georgetown.
Yes.
Meeting. I think 9 o'clock is the start time. It goes to 4:30, but I suspect that people do not need to be there for the entire day, John?
Well, they're welcome for the entire day. We'll serve. But no, whatever you can come for would be great.
Excellent. And I will also remind folks on the line that PILIG is handling the ASIL attendees at UNCITRAL, so keep your eyes on the emails. I send those out intermittently along with my co-chair, Cristian Jimenez-Corte. So with Cristian and with David and John, I thank you, the attendees, and David and John, thank you for your fantastic and wonderfully informative discussion.
Pleasure.
Pleasure. All right.